Welcome, everyone, and thanks for joining our September edition of Voices for the West, a webinar series brought to you by Advocates for the West. My name is Will Shoemaker, and I am Communications and Engagement Director at Advocates for the West. The title of today's webinar is Recent Supreme Court Rulings and the Future of Environmentalism. We're honored to be joined by Melissa Powers, who is Jeffrey Bain Faculty Scholar, Professor of Law, and Director of the Green Energy Institute at Lewis and Clark Law School, along with Ben Chagnon, Senior Counsel for Strategic Legal Advocacy at Earthjustice, and Andrew Missel, Staff Attorney at Advocates for the West. Before we dive in, I have a request of you, our attendees. At the bottom of your screen, you should see a chat section. And so that we can better get to know everyone before we actually dive into the actual webinar, please take a moment and drop into the chat your favorite environmental or land management law. I am writing into the chat now. ESA, or Endangered Species Act. I once had a colleague who called the ESA poetry, pure and simple. I'm neither an attorney nor a poet myself, but I'll take their word for it. You will remain on mute throughout the course of today's talks. However, we do welcome your questions. And here's the important part. If a question comes to mind at any point during the course of today's talk, please drop it into the Q&A section. Q&A is also located at the bottom of your screen, but is different from the chat section. You don't have to wait until the end of the talk in order to drop your questions into the Q&A, and we'll get to as many of those questions as time allows toward the end of today's webinar. Wow, so we have lots of Clean Air Act, the Wilderness Act, FLIPMA. Thanks for sharing that, everyone, and letting us gain a little bit of insight into what you're interested in as an attendee. I will be dropping off the screen here shortly, but will return for our Q&A with attendees during the latter part of the webinar. So please give us some good questions for our panel. Without further ado, I will turn the floor over to Advocates for the West Staff Attorney Andrew Missel. Andrew.
Thank you. And actually, Justice Gorsuch put out a poll like this recently too, but it was, which environmental law do you want to see gutted next? I think the Clean Air Act one. No, I'm just kidding. Thank you, everyone, for joining us. Thanks so much to our panelists, Ben and Melissa, who are going to have tons of smart things to say, and me, who's going to have fewer smart things to say, but I'm going to be asking the questions that will inspire those smart things. So just to give you a little bit of background, I think most of you who are on know this, but the Supreme Court in about 4 years ago, after Justice Ginsburg died, and then President Trump replaced her with Justice Barrett, that gave the Supreme Court a 6-3 conservative majority. Although I think maybe even more important than the political valence is the fact that there's now enough votes on the Supreme Court to essentially say LOL, stare decisis, and overturn decades of precedent. And we've seen that happen in the last few years, both with environmental laws and maybe even more importantly with administrative law. And so we're going to be talking today about a number of decisions that the Supreme Court has made in the last few years that are going to have a huge, are already having, and are going to continue to have a huge effect on the way that environmental litigators work and on the way that the environmental movement more largely works. Some of these cases you've probably heard of. There's the Sackett case, which is about the Clean Water Act. Some of them are a little more obscure, maybe, like Loper-Bright. Maybe that's not too obscure, but Loper-Bright, which overturned the Chevron doctrine. Corner Post, which is about statutes of limitations for challenging federal rules and regulations. So all of these decisions, though, are very monumental, even when they seem very technical and abstract. So I think we're going to start off with, we're going to attempt to start off on a note of optimism. So a lot of the discussion in the environmental community around these decisions has been, pretty negative, and there's a good reason for that, especially with decisions like Sackett. But I want to ask a question for our panelists. What new opportunities might some of these decisions offer for environmental litigators and environmental activists? And I'm thinking more along, not so much about Sackett and actual environmental cases, but more about like Loper-Bright, which kind of rebalances the power between courts and administrative agencies, or Corner Post, which changes statutes of limitation, which effectively changes the statute of limitations to challenge agency actions. Are there some doors that maybe were closed in the past that might now be open? So let's start off with Melissa, that question.
Sure. Hi, everybody. I'm really happy to be here. And as an administrative law professor, sometimes in this webinar, I'll do a little bit more background admin law-y stuff just to make sure everybody has a good understanding of the underlying doctrine. So as Andrew mentioned, the Supreme Court recently repealed its decision in Chevron, which had said that involving questions of statutory interpretation, it used to be that where a court determined that a statute was ambiguous, it would then defer to an agency's reasonable interpretation of what that statute meant. Now, what the court has said is that at least through interpretations that arise under the Administrative Procedure Act, which is the default statute for judicial review, unless another statute specifically has statutory review provisions, that deference to an agency's interpretation is no longer appropriate. So instead, it will be up to the court to decide what a statute means, whether the statute is clear or whether the statute has some ambiguous meaning. Now, the court might look to some degree of agency explanation, but it doesn't have to defer to it. There might be a category of statute that delegates to the agency interpretational powers. And in that case, the court might give some degree of deference to the agency's interpretation, but we're waiting to see what will happen there. So that's the Loper-Bright case. And that, first of all, could open up for environmental NGOs and other more public interest-minded advocates opportunities to challenge agency regulations and other interpretations that the advocates might have previously thought were unavailable for them to realistically challenge due to this strong deferential doctrine. So there might be the case that where there's a better reading of a statute than what the agency has offered, a court employing its traditional tools of statutory construction could rule in favor of environmental organizations. So that's one bit of background. Second bit of background is the Corner Post decision, which actually could open up to judicial review many long-standing regulations that most people had thought were out of touch for judicial review due to the statute of limitations. So again, this is a case that involves the Administrative Procedure Act, and the APA does not itself have a statute of limitations, but there is a generally applicable federal statute of limitations that is a 6-year statute of limitations that arises when a claim accrues. And what the court said in Corner Post is that in challenges under the APA, a claim accrues when a plaintiff actually first has the right to assert a claim in a court. And this is because under various parts of the APA, a plaintiff to be able to bring an action in a court must show that the plaintiff has been injured, number one, the APA says adversely affected or aggrieved, and that it is injured by a final agency action, number two. So the reason that Corner Post is a really big deal is that many courts before this decision had said that where a regulation has been promulgated, the statute of limitations begins to run after the date of promulgation, and technically after the regulation takes effect, which is after it's published. So if you have a statute that's on the books and you wanted to bring a claim against that, excuse me, where you have a regulation that's on the books and you want to challenge that regulation pre-corner post, you would have to have filed your challenge to that rule within the 6 years after it was promulgated. And what Corner Post involved is an actor who was incorporated 6 years after a regulation it didn't like was promulgated, and it came into operation 7 years after the regulation took effect. So clearly past the statute of limitations, but they didn't like the rule. And so they brought a facial challenge against the rule, saying that it was inconsistent with the statute. And the Court of Appeals dismissed the case, saying you're well beyond the statute of limitations. And the Supreme Court said, no, actually, they had the right to challenge that rule. And so there are a lot of questions about the implications of Corner Post, including the fact that we generally assume that regulated entities come into their business with the background of existing law covering them. So they themselves might be able to try to challenge and upend a whole lot of regulatory law that we might like. But the flip side is that there could also be opportunities for environmental organizations to, once existing law is applied adversely to them, to challenge the foundation of that existing rule by saying it may be inconsistent with statute or perhaps arbitrary and capricious. So that's my overview, and then I'll let Ben talk a little bit more about where he sees the opportunities from the environmental perspective.
Thank you for that overview and for some optimisms. So I really want to treat the question seriously and find optimism. So I think it's difficult, but I think where I'll start is kind of similar to on kind of both points, is that there is no doubt that Chevron protects a bunch of agency regulations that are not as protective as environmental litigators would like. Pretty frequently in cases, you will have the EPA will come out with a regulation or a rule, and both industry will challenge the rule as being too protective of the environment, and environmental litigators will also challenge the rule as not being protective enough. So in those cases, it does open up a possibility that once deference goes away, that there's maybe more upside for environmental litigators to potentially get the court to side with them on how to interpret the statute. And this is always like kind of a semi-amusing note, but Chevron is named Chevron after, the oil company, but the person trying, or the group trying to challenge EPA's regulation in that case was NRDC, the very famous environmental group, nationwide environmental group, and they were saying the agency's interpretation of the Clean Air Act wasn't protective enough. So that was true from the beginning, that Chevron deference could stand in the way of environmental litigators achieving their goals. It's been true over the years, and it will be true going forward. And going forward, it may be easier to have success. But I do think probably the headline here is probably not necessarily one of optimism. And I think one way to see that is that the reason industry has been pushing cases like these, and it's not just Corner Post and Loper Bright, but there's a case called Sackett, which is about the Clean Water Act, and West Virginia v. EPA, which is about this doctrine called the Major Questions Doctrine, which is a pretty big deal, but also very mysterious in name, and we maybe talk about it later. It's due to a kind of calculated decision from industry in certain red states that they're going to do better off in courts, where courts have the final say about what nationwide policy is, and they'll do better than if agencies can do that. So it may be well that there are some cases where environmental litigators would do better, but at the same time, any argument that environmental litigators makes in those cases to say we should open up more stuff, including old rules we don't like, that this industry in red states will be making those same arguments. So there has to be a measured approach about kind of what's the best approach for kind of leaving the status quo in place and things like that. And I'll just offer kind of one maybe meta commentary, which is one of the great virtues of Chevron, both as a decision-making rule, but also in terms of how agencies do their business is that it emboldened agencies to be a little more risk-taking in terms of their interpretations. They kind of had room to breathe, which allowed them to say, the agency followed the right process. They had a fairly reasonable interpretation of a statute, so we can be more environmentally protective here than we'd have to be if we took the most conservative approach. And so I worry a little bit that the decision may cut back on that. So there's definitely room for caution. But as Melissa says, there's also like what I'm thinking of like an oasis of optimism within my like gloomy swamp, which is the court didn't go as far in Loper Bright as it might have. So it offered kind of a set of circumstances where Congress is still allowed to give agencies authority to interpret the law, give agencies kind of the most respect for their interpretations of the law. They can use phrases like appropriate or reasonable, or they can expressly delegate to agencies, or as the court says, let them fill up the details. So that is encouraging in terms of allowing agencies to have room, and that often is a place where environmental organizations can influence agency policy through comments and things. So giving them the detail they need to make these technical judgments that agencies are best positioned to make. And then the other note of optimism, which isn't about a new open door, but maybe closing a door in an optimistic way, is that the court at least said, as a matter of stare decisis, as much as they don't want to allow stare decisis to save Chevron itself, just because an old decision that upheld an agency action relied on the Chevron framework, finding agencies okay because it's a reasonable, agency rules okay because it's a reasonable interpretation of a statute. The court said, we're not going to throw all those out as a matter of stare decisis. You have to show some special justification for revisiting it. Or as Melissa says, maybe it can be revisited in the context of when the rules later applied or something like that, but at least there's some stability there. So that's Loper Bright. I think my view on Corner Post is that I think it's a very big deal in administrative law generally. I think the sunny moment for maybe environmental lawyers is that Corner Post itself was very focused on that federal statute of limitations provision that applies to APA claims. A lot of the environmental statutes have their own statute of limitations provisions that are written a little differently. They're not kind of about when a person is adversely affected by the agency action or something like that, or a claim accrues. They're tethered directly to when the agency first promulgated the rule. So for a lot of environmental rules that environmental litigators like, it will be harder for industry or red states to challenge those old regulations. So that's true under the Clean Air Act, Clean Water Act, Safe Drinking Water Act, and a bunch of other statutes are written to have particularly short and definite statutes of limitations, or sometimes called statutes of repose, that will make it harder to go nuts on some of these old rules. So I cheated a little. I didn't really answer Andrew's question, but I offered a little, and then I'm sort of pessimism and then optimism within the gloom. So I think that's where I'm at right now. But the bottom line is we're also really seeing how courts are going to work through these doctrines. And we're starting to get that in the courts of appeals. The Fifth Circuit's been very busy in expressing their views about what's going to happen. DC Circuit's starting to think about it as well. And so far, I don't think there's been any huge different outcomes from what we'd expect necessarily, but there's a lot of development to still do. The Supreme Court left a lot of questions open about how things are going to proceed going forward.
Could I make two other quick points? So the first is, I actually think there's a little bit of tension between Loper Bright and then Corner Post in terms of this statutory stare decisis, because, and I'm sure most of the people on this webinar are familiar, but there's this ongoing debate about when a court can set aside or vacate an agency rule. And in some statutes, like the Clean Air Act and the Clean Water Act, a lot of regulations are subject to judicial review by the DC Circuit, especially the Clean Air Act. And once the DC Circuit rules, other courts are not going to have the opportunity to review those regulations. So that's where statutory stare decisis is going to be the clearest. The really interesting thing to me about the Corner Post case is that the regulation that Corner Post wanted to challenge had in fact been challenged by other groups after it was promulgated, and the DC Circuit had upheld it but this was a type of statute that could be challenged in any court. And so I think we're actually going to see a lot of circuit splits in those statutes that don't have statutes of limitations, but we're looking at the default federal statute of limitation and where you could get judicial review by multiple courts. And we're already beginning to see scenarios where one court is upholding a regulation and another court is not only invalidating it, but setting it aside. And we've seen this actually under the ESA, where there are different rules in different jurisdictions, meaning federal circuit court jurisdictions, due to the fact that Fifth Circuit doesn't control what happens, for example, in the Western United States. So I think things are going to get very messy and interestingly messy, especially as a result of the reopening of the statute of limitations. So that was the other thing I just wanted to note.
Yeah, and of course, once there is a circuit split, that greatly increases the probability that the Supreme Court will take up the case and then decide it. So even if there was some statutory stare decisis that would protect things in the DC Circuit, the Supreme Court might hear some issues that they otherwise wouldn't have heard. And that's not a good, that's in general not going to be good for us. All right, so that was, believe it or not, the optimistic portion of the program. We are now going to turn away from that oasis of optimism to the desert, and talk a little bit about Sackett versus EPA. So I think Melissa will explain a little bit more what that case is about, but very, very briefly, it's a case that limits the waters and wetlands that are subject to federal jurisdiction. In other words, where EPA and the U.S. Army Corps of Engineers can regulate pollution in those waters. But this is, I'm not trying to be optimistic here, this is just a fact of it, it leaves those waters still to regulation by the states. So states can still regulate these waters. So my question is, what do you think the prospects are for states filling in some of these regulatory gaps, which I know some states, I think Colorado, have already started to do. And to what extent can that even be done? I mean, one of the things you learn in law school and environmental law is, well, the reason we have federal environmental laws is because pollution doesn't stop at state borders. So even if states can fill in some of these regulatory gaps, what good is that if they can't all do it? And then I guess this is more of a question for Ben. Do you think that litigators and also sort of grassroots activists need to spend more time at the state and local levels advocating for clean water there rather than at the federal level, given Sackett? So we could start with Melissa.
Sure, and I'll just add a little bit more content to the Sackett decision, which the Supreme Court has heard several cases involving the question of the scope of the Clean Water Act. And in particular, EPA has long tried to regulate, under its authority to regulate, quote, waters of the United States, not simply navigable waters and the things that obviously would strike us as being a water of the United States, like lakes and rivers and territorial seas. But EPA has also sought to regulate other hydraulic features that significantly affect the water quality of these traditional waters of the United States. So the Supreme Court several years ago, in the prior to the Sackett decision, the most important waters of the United States ruling, ended up with a 4-1-4 decision. In which the one decision, the concurrence, basically became the law of the land, and that law of the land said that it was fine for EPA to use a significance nexus test to regulate basically non-navigable, non-traditional waters if in fact they did have a significant hydrologic connection to these traditional waters. The Sackett decision overrode that. And what the Sackett decision basically said is that, first of all, EPA has authority to regulate as waters of the United States only those, this is a quote, relatively permanent, standing, or continuously flowing bodies of waters that form geographic features that are described in ordinary parlance as streams, ocean, rivers, and lakes. So that's subject to regulation. And then the specific question in Sackett was, well, what about wetlands? And in particular, because the Clean Air Act authorizes regulation of wetlands adjacent to those traditional waters of the United States, what does adjacent to mean? And what the court said is that wetlands are covered if they are specifically connected to and have a continuous surface connection to the waters, that there cannot be a clear demarcation between the waters and the wetlands, except it might be okay that there could be some degree of temporary interruption in surface connections as a result of things like low tides or dry spells. So in practice, what this means is that if a wetland is not directly adjacent to, meaning connected to on a surface basis, a traditional water, it is not going to be connected. And so among the things that in his concurrence, Justice Kavanaugh identified as being no longer regulated under the Clean Water Act are wetlands that are separated from the traditional waters by human-made barriers like levees or roads. There was a road separating the property in Sackett from the lake at issue. Natural river berms, beach dunes, and a host of other naturally occurring impediments, even if there is a clear ecological connection between those water bodies or the not unregulated water bodies and the traditional water bodies. So that has opened up a huge amount of non-adjacent wetlands, marshes, other things that don't have a clear surface connection to a traditional water body to development and discharge of dredge and fill material and so forth. So, and one of the reasons the court used to justify this narrowing was federalism concerns, which does mean, as Andrew indicated, this is going to the states. And it probably does mean, therefore, in my view, and Ben can speak more to this, there has to be way more advocacy at the state level to protect these water resources.
No, that's such a great summary of the problem, and I'll pick it up from there. So I think you know, just to kind of bottom line it from Earthjustice's perspective, who closely watched the decision, after Sackett removed protections, it's estimated that it removed protection for maybe 118 million acres of wetlands, or approximately 60% of the wetlands the country has left. So it is a big problem. We could talk about the virtues of wetlands probably for an entire session, just how important they are ecologically, but it left a huge hole. So, and as Melissa says, one reason the decision was so important is because it is in a federalism system, and a lot of states borrowed the Clean Water Act's definition of what waters of the United States meant. So automatically, those states' independent regulatory provisions relating to waters were also thrown into doubt. So still, maybe here I can actually be a little more optimistic. We'll see. At the point protection was removed, there were quite a few states that had some protections independently of wetlands. There's a handful of states that had good law. So Washington was one of these, California was one, some states in the Northeast, and there's others. There were states that were really far behind. Colorado wasn't quite there. Montana, which has quite a few wetlands, wasn't in the quite far enough along in protecting that, and New Mexico is another example. So the good news is that in the last year, there's been a lot of advocacy at the state level to try to get legislation to fix the problem. So we've seen already examples of this happening in Colorado, as Andrew mentioned, other efforts in Illinois, and efforts in New Mexico, and I think others are ongoing. Okay, so back to less sunny news. Other states predictably went the other way. So North Carolina decided, oh, we're going to make sure to make clear that our definition is no more protective than the federal approach. So that's bad news. And then Indiana also pulled back protection, and there's a number of other states that are contending with these kind of things, like Missouri and Florida have bills that are potentially pending on these things that they may have to deal with. So that's kind of what the legislative efforts look like. There's some success, and that's been kind of a mixed bag, but there's in some of the states where it matters most, there is progress. The other thing to flag is that sometimes beyond legislative efforts, there's other kind of local things that either litigators or local regulators can do, which is to use like land use or other type of state laws to not regulate kind of emissions into the pollution into the wetlands directly, but to surround wetlands with zoning laws or the kind of right buildings that won't produce the worst kind of effects, or use zoning and other smart laws to protect wetlands in a different way. And there's been some success there as well. And some, states are allocating funds for that kind of work. So I think the bottom line is that Melissa is absolutely right, and that, as Andrew's question, I think, was hoping to go, is that like coordination between kind of folks who think about national Clean Water Act policy and state level policy and national litigation and state level litigation under state laws is critically important. So one thing that Earthjustice does, for example, is we have people litigating or thinking about litigating these issues or developing these issues in state courts directly. What other laws can be used under state law to kind of achieve the same goals? Earthjustice also has a policy and legislation team that thinks not just about federal law, but does coordinate quite closely with movements and frontline communities working on these issues at the state level and trying to get legislative successes at the state level. So I think it's critically important to try this kind of belt and suspenders approach. Be great to litigate and get the Supreme Court to somehow change its mind on what does the United States means, or to look for other creative ways there. But I think sometimes getting state law changed or advocating using other state laws to get to the same place is super important.
Yeah, and I'll just say, obviously it's harder and it's more expensive, and the amount of coordination it requires, it makes it really difficult, I think, to make progress as fast. But I know in other areas outside the environmental context, because this Supreme Court has been bad for the environment. It's also been bad for a lot of other things. And so outside the environmental context, I know, for instance, the ACLU in recent years has started this state Supreme Court initiative where they're working more in state courts to protect reproductive rights, et cetera, because they realize that it's going to be a tough row to hoe for the next decade or more in the U.S. Supreme Court. Okay, I want to talk a little bit about standing. And for those of you who are in the audience who don't know what standing is this judge-made doctrine, ostensibly based on the text of the Constitution, that limits what kinds of cases can be brought in federal court. So basically, the Supreme Court over the years has developed this doctrine that says, if you want to bring a case in federal court, you need to have an injury. You need to show how the thing you're challenging has injured you. You can't just come in and say, I don't like this law because it bothers me. You have to show how you personally, or if you're an organization, a member of your organization has been injured by this law. Now, in the last couple terms, there's been some interesting standing decisions, none of them in environmental cases, but all of them with the interesting political valence that they're actually brought by a lot of conservative activists, and the Supreme Court has kicked them all out, saying you don't have standing. So just to mention a couple, I think the Alliance for Hippocratic Medicine case was pretty high profile. That was a bunch of doctors challenging the FDA's approval of mifepristone. There's United States versus Texas, where the state of Texas, and I think another state, essentially challenged the federal government's immigration and enforcement priorities. And personally, I worry about standing. Standing is the thing that keeps me up at night. And when I saw these cases coming down, I was very worried that the Supreme Court was going to take the opportunity in one or more of these cases to cut back on standing doctrine in a way that would really, really undermine the work that I do and the work that people in the environmental nonprofit space do. I'll just say my kind of, I feel a little relieved in that my sense is that these cases didn't really make any huge changes. They just sort of reinforced what was there. But I'm curious to know what the two of you think about these cases, and whether you think they've made any, did the Supreme Court kind of cut back on standing to just reaffirm the already kind of frankly bad standing doctrine? And how do you think the lower courts are going to apply these decisions to environmental cases going forward? And sorry, we'll start with Melissa.
Yeah, so first, I generally agree with your sort of sense of relief. I think that actually a couple of the cases, all they did was restate existing doctrine. And actually, the mifepristone case, while there's a little red flags that I will raise, it actually specifically recognized certain types of environmental organizational standing. And so, first of all, the things that I think don't matter in the US v. Texas case, the challenge to the Biden administration's enforcement priorities, they basically said that they were going to prioritize deportation of people who were in the United States illegally. They were going to prioritize deportation of suspected terrorists and dangerous criminals. And Texas and Louisiana said you need to also focus on other non-citizen deportation. And the court said, we have a law that's nearly 50 years old that says, actually more than 50 years old, that says that a citizen lacks standing to contest the policies of the prosecuting authority when the person is neither the prosecuted nor threatened with prosecution. So just because they were states, and what the states were trying to say is we're special, federalism, Mass v. EPA, we get special solicitude, we can have more role to play in dictating federal enforcement priority. And the Supreme Court rejected that. And so it just re-embraced existing law. Another recent standing decision involved states suing the federal government, alleging that the federal government's interaction with technology platforms related to things like COVID misinformation and election misinformation basically amounted to a suppression of free speech rights. And the short and long story is that the court said, you're arguing that somehow the federal government coerced these tech platforms, but the tech platforms aren't arguing that. So this really isn't your case to be able to bring. So it's like a type of derivative standing where the states couldn't show that they had suffered any type of injury, and they were trying to basically create and invoke an injury. And the court said that that just didn't amount to a cognizable injury in fact. So the bigger deal case to a certain degree, but it's both good and bad, is the mifepristone case. And this is a case in which doctors and an organization, a right to life organization that had formed, were upset that the federal government had loosened access parameters for mifepristone, which is an abortion medication. And their theory of standing was that if more people have access to mifepristone, more people will need emergency room services. And some of these doctors were ER doctors, and they would be forced to maybe give emergency abortions in violation of their conscience objectives. The other thing that they had argued is that they would suffer economic costs by being forced to treat some of these patients more as a result of what they saw as the increased risk of complications from using these medications. And somehow by having to treat more patients, they would incur more costs than they wanted to. They didn't quite sketch that out. And then the third is that the organization, the trade group that had formed, argued that they themselves suffered an organizational harm. So the first two claims the court rejected on causation grounds and basically said you can't connect the dots. And so this is actually a good case to read to understand the importance of dot connecting when you are not a regulated party, but you're claiming impact from regulation, that you have to draw, and the court emphasizes the need to draw clear connections between the action that you're challenging and the harm that you're suffering. And in this case, they couldn't raise these conscience objections because there are actually federal laws that say if you have a conscious objection to providing emergency treatment that involves abortion, another doctor will be asked to perform that medical treatment. And then in the context of the financial consequences, it was just incoherent. And then for the organizational standing, the court said that an organization can't exist for the purpose, basically, of challenging regulations and just claim that they've suffered an organizational harm because they actually have to expend resources to challenge the regulation that you don't like. And that's been the case for a long time. That's why we have representational standing, where organizations have members whose direct interests are being represented. My view, and then the last thing I'll just note in the Mifepristone case, is that the court specifically distinguish their claim of causation from environmental organizations who want to raise a challenge to what the court said is when the government regulates parks, national forests, or bodies of waters, for example, the regulation may cause harm to individual users. And that's the type of harm that environmental groups raise all the time. And it clearly accepted that as a causal link. So my view is that post, probably at least post Summers and some of the big Supreme Court cases about environmental standing, environmental groups already do this. They already connect the dots. I think the only thing that I would highlight is that to the extent that your claim of standing involves some degree of scientific proof, I encourage every environmental organization not just to submit affidavits or declarations from members, but to have scientists submit information to actually back up those assertions. Because at least in the climate space, with the first wave of climate litigation, there were a lot of just individual members saying, I'm worried about climate change, and I therefore challenge this agency action. And those lost. And it was actually a body of case law that was very dangerous. Environmental groups have connected, but this wave of litigation that we were just talking about indicates the importance of actually having scientific, factual proof to underline your standing claims.
So I'm happy to add a little bit more. I don't have that much to add. I think my bottom line is the same, is that these decisions don't do anything terribly new. They operate in what tends to be a very hard space for standing litigators when they're trying to establish standing, which is explaining how third parties will react to the government action you're challenging. And there's been a set of cases over the last decade or so, one called Clapper, and then there's the census case that kind of get into this, and you have to establish that the third party will react in a predictable way. And so that law was pretty settled. And one thing I'll add a couple things on this, which is that if you read the Murphy decision, which is this case about social media, and you read kind of the majority opinion, which is by Justice Barrett, and then you look at the dissent from Justice Alito, that mirrors some of the debate you often see in any given standing case in the Court of Appeals, where one judge or justice is very willing to help connect the dots. Like Justice Alito was very willing to help connect the dots between these claims, whereas Justice Barrett was very skeptical. And those same dynamics appear across certain judges in the DC Circuit and in the Fifth Circuit. So so I think that's nothing new. And the second thing I'll add is that there's a sort of interesting dynamic here where the Fifth Circuit keeps finding standing, which is maybe surprising because you think the Fifth Circuit is very conservative. But this dynamic also plays out in courts like the DC Circuit, which is sometimes judges who may be more dispositionally conservative want to open up standing because it allows industry and states more leeway to challenge federal government action they don't like. So it's this interesting area where there's a bit of a flip sometimes from what you might expect from these courts and these type of litigators. So, but I think Melissa has it exactly right, is that for the most part, environmental lawyers know how to do this really well. It's about connecting the dots each step of the way. They know how to find the right declarations and affidavits. So this shouldn't be a huge new lift. That said, whenever the Supreme Court says anything new about standing, I'm always a bit wary, issues a new standing, that I'm wary that courts will pick up on things or try to use those cases to suggest that the rule's harder than it is. So whenever the Supreme Court doesn't find standing, it does create some opportunities for mischief. But I will just say the organizational standing, again, that also may be closely restated existing law, but it did contain the suggestion that for any of the courts we're thinking about expanding it at all, no, you should limit it to this one case that we had a long time ago called Havens Realty. And to the extent people are entertaining expanding it at all, good luck. Like that's not really on the table. So that's something we're thinking about because often environmental groups will use organizational standing because there are some non-member organizational groups. But the other thing that I'll highlight that I don't think has been discussed, there is this separate concurrence from Justice Thomas that says this idea of representational or associational standing, which is very commonly used by environmental groups where, if you're a member of, say, the Sierra Club, Sierra Club brings suit, Sierra Club can bring suit on behalf of you. Justice Thomas suggested some skepticism about whether that should be a thing at all, that we should have associational standing. It's not the first time he's thought this. It's not the first time anyone in the courts have thought that, but that's another thing to keep an eye on about something that might happen in the future. So I think overall, no big changes here. Interesting flip dynamics, but it is a strong reminder that you have to tie up your standing in every case you litigate, including with affidavits that from experts where appropriate, or even in sometimes what you'll try to say is that third parties will react because they have economic incentives to behave a certain way. Sometimes that seems like common sense. Like if you raise the price of natural gas, more natural gas might be sold by people who refine it. Sometimes courts will want like affidavits that say like common sense stuff too. So that's a good reminder of all of this stuff and something that we should all be reminded of making sure to dot our I's and cross our T's on standing.
Yeah, and I'm relieved to hear that both of you generally are of the opinion that these don't change anything all that much. And I'm glad, Ben, that you brought up Justice Thomas's concurrence, because we all know that today's crazy Justice Thomas single justice concurrence is 5 years from now the new opinion of the court. So it's a good thing to bring that up. And yeah, I'll just also say, just as a sort of aside, what you just said about it flipping sometimes. I mean, this is exactly why standing is such a problem, right? It's this doctrine that is supposed to be supposed to limit the judicial role, but in fact, it's infinitely flexible and allows judges to just implement their policy preferences and find standing where they want to and not find it where they don't want to. All right, I think we have brief time for one more question. And this has to do with, this is maybe more of a question for Ben, because it's a question about strategy and how we deal with this Supreme Court majority, because the truth is it's going to be here for a while. It might be a decade, it might be 2 decades. And I'm not, I think one strategy is, well, let's try to keep as many cases that we care about out of the Supreme Court. And I'm wondering, that seems like a good strategy for 2 years or 3 years. And I'm skeptical that that's a viable strategy for 2 decades. So I guess the question is, what do we do, or is there nothing to be done? Is it just about harm reduction with the Supreme Court?
No, I think that is the question that I think environmental lawyers and other folks in progressive NGO spaces have to deal with. I think we talked about one thing that can be done already today in the context of SACIT, which is states are out there and they can provide a lot of protection in their own right. So I think that's one thing that can be done. I think the other thing that can be done generally, and this is, I think, building off the theme of the standing thing, is that to the extent environmental litigators can, dot their I's and cross their T's in everything they do, it makes it a little harder for the Supreme Court to at least reverse things by picking off low-hanging fruit. And they can do that in the arguments they make in cases, but also in working when the federal government is able to be working with agencies to help shore up their records and things like that, to at least make it harder for the Supreme Court to come out the wrong way. So I think you're right. The first best line of defense is trying to keep cases out of the Supreme Court. That's something you most obviously do at the cert stage itself. Environmental groups don't like to file cert petitions very often. So that would be sort of obvious, but trying to resist cert where you can. I will say that one dynamic that's emerged and became very apparent in the last term is that it's harder to even keep cases out of the Supreme Court because there's this recent ish phenomenon that's accelerating that I'm sure folks have read about, called like the shadow docket or seeking emergency stays, where big environmental rules from the Biden administration basically immediately get challenged, and then they immediately get challenged by industry in red states, who will often go right to the Supreme Court to say, stay this thing. Don't let it go into effect before we can even go through the normal process. I mean, last term, the Supreme Court did a remarkable thing where they heard oral argument on one of these things in a case involving what's called the good neighbor rule, which deals with the very difficult problem of upwind pollution. You know, the wind doesn't care about state lines, so it sends ozone downwind and impacts that. EPA had come up with a rule, and the history there is very complicated, but then it went up to the Supreme Court, and the Supreme Court, in a very kind of ticky-tack administrative law case, said, okay, we're going to stay this thing. And then the result after that has been kind of, there's a difficult path forward for the government to try to get that rule going or back in place. So I think it's, even if you avoid the sort of normal old school way of getting things to the Supreme Court, there's this emergency stay path. Right now, there are at least 3 emergency stays in important stay proceedings in important Biden administration rules that are pending in the Supreme Court. They haven't resolved them yet, so I think we can see that pattern to continue. So that's like a frustrating. We're out of the oasis, back into the swamp or the desert. But the other thing to think about in terms of keeping cases away is that it's not just kind of at this last step. There's a lot of thoughtfulness that can be had about what arguments you can make in the courts of appeals. Like, for example, right now, if I was trying to think about arguing something aggressive on organizational standing, that may be unwise given the recent decision suggesting that there's at least some work to be done there about that unsettled that law in a way that could be challenging. So you have to pick your spots. And that doesn't mean just trying to avoid, for example, the Fifth Circuit, which is also sometimes a little more skeptical of environmental groups' arguments, but sometimes it also means avoid making good arguments in the DC Circuit, because if those courts come out different ways, that creates a circuit split. So I think it's really about picking your spots. But as you say, you can't kind of cede ground altogether, because if you make no arguments, then that's almost as bad as the Supreme Court having ruled in the negative way. So I think that's the balance. But yeah, I think figuring out the solution here is very difficult. But I think that this reality of needing to keep things out of the Supreme Court, resisting stay, trying to dot your I's and cross your T's the best you can is going to continue to be a really important one.
Yeah, exactly. Picking the right cases, making sure that you're, very solid on standing, very solid on all of those issues. And yeah, I don't think there's any right answer to this question, because as you say, I think the other thing to note about the Supreme Court in recent years is that in the past, I think they cared about what's sometimes called the vehicle issue. They wanted to take cases, even if there were 5 justices on the court who were like, oh, we can't wait to cut back on the Clean Water Act. They wanted to wait for the right case to do it. And in recent years, not just in environmental cases, but in other cases, they've shown a willingness to sort of take cases that are bad vehicles, that have bad facts, and just sort of either ignore those facts or make up new facts and decide the cases based on those made up facts. So I think it's trick. I think it's a court that is very eager to put their stamp on the law, and it's hard to keep things out of there. Even if you have what would be traditionally considered good arguments for keeping cases out of there. Will, I don't know, do we have any questions, Will, or are we?
Yeah, we do have one question here. A reminder to our attendees, if you have any questions for our panel, please do drop them in the Q&A section at the bottom of your screen. The question that we have, and we'll see if we get any others, is around advocacy and lobbying. Ben, you mentioned certainly Earthjustice and many other groups are involved with advocacy and lobbying at the federal level. How much political will is there currently to shore up some of the protections that have been lost by recent Supreme Court decisions? Is that political will changing at all? Is it growing? What do you see happening there?
So with the caveat that sort of my role within Earthjustice is more litigation, and we have separate teams that is way smarter than me on all this stuff about kind of how to work with legislators. I think some of the difficulty is, from our perspective, is an education effort to help folks understand what these doctrines were doing and why they're important and how they matter. So I think once we have educated folks, they get it, and there's ideas about what to do with it, and to say, oh, maybe we can try to change or improve things. I think the idea, for example, of reinstating Chevron at the federal level would be really challenging. But maybe more modest goals, and sometimes we work with our legislative folks on this, is maybe to come up with guidance that we can give to people who are writing legislation about kind of best practices. So we can take those in almost instructional manual that the Loper Bright decision had about how to write legislation in a way that does give more authority to agencies, or how to write a statute of limitations provision that does insulate agency action. I think there's a lot of interest in that as well. So I think people get it. I think it's just a difficult moment to get kind of these broad sweeping changes back. But I think there are a lot of smaller things that legislators can do to read and understand Loper Bright and Corner Post and cases like that really well, and draft legislation to at least avoid some mischief by, like, say, the Supreme Court, who wants to read it in an unfriendly way.
I want to give Melissa an opportunity to weigh in on that question also. Anything you would?
Yeah, I mean, there are a couple of proposed bills. One to basically restore some degree of deference that Senator Wyden, a senator here in Oregon, has drafted and has some signatories. And then there's actually a bipartisan bill that's been drafted in the Senate to reverse the Corner Post decision, largely because they're concerned about sort of statutory mayhem that might result if the statute of limitations is gone. And then could I just add one quick thing about the court? Number one, it's going to depend a lot on what happens with this election. And I just want to emphasize that Martha Ann Alito, Justice Alito's wife, for example, was interviewed as saying that she can't wait for him to retire so they can fly whatever flags she wants to fly. They are waiting for, he and Justice Thomas, all reporting indicates, is waiting for Donald Trump to be reelected president so that they can be replaced by people who are maybe even further to the right than even Justices Alito and Thomas. So reverse is that they might stick around a little bit longer if Harris becomes president, but they might not, because they are also quite old and they want to do other things with their lives. So I just want to emphasize, we're not stuck with the court that we have for decades, depending on what happens with the election. Sorry to make it political, but in reality it is. What Andrew was saying, I mean, several of the cases we've talked about were completely moot before the court ruled on them. So this is a very political issue.
Well, thank you very much, Melissa and Ben, for sharing your expertise, and Andrew for your thought-provoking questions. Thank you very much for joining us today. Thank you to our attendees for showing interest in this topic. I will say the important environmental work that groups like Advocates for the West and Earthjustice and professors of law at schools like Lewis and Clark are doing is fueled by supporters like you tuning into webinars like this one and becoming inspired to get involved. If you do feel inspired by today's webinar, we hope that you will support our work in a way that works for you. I will be sending a follow-up email that includes a link to a recording of today's webinar on YouTube. Please feel free to share it with folks who you think might be interested in the topic who weren't able to join us today. We also hope that you will tune in for our next Voices for the West webinar in late October. If you're not already following Advocates for the West on our email list, sign up and stay tuned in the weeks ahead for more info on that webinar and other Advocates for the West happenings. And with that, I hope everyone has a wonderful afternoon. Thank you, everyone.
Thank you very much.
Thanks for having me.